So, good morning, everyone. Thank you for joining us today on today's HR Matters, brought to you by the Sheffield Employment team. We're running this session a bit different to how we've done the previous ones. Due to the amount of questions that we've had in beforehand, we're going to do a Q&A session at the beginning. But if you do have any more questions, then please use the Q&A function at the bottom of your screens, and we can answer these at the end. If you do have any technical issues as well, please use the chat function for this. I'll hand you over to Tom briefly. Thanks very much.
Brilliant, thank you, Tom. Hello, welcome, good morning, and happy Tuesday. My name is Tom Draper. I'm the Head of Employment at the Freeth Sheffield office, and I'm joined for this morning's webinar by Toby Pockran, who's a Managing Associate, and Lee Williams, who's an Associate in my team. So we are going to look this morning at a variety of questions related to coronavirus. As people managers and HR managers, we're used to adapting quickly to changes in legislation, but this year has really been unprecedented in terms of the amount of change. And the latest lockdown, the availability of mass COVID testing and the mass vaccination programme has brought even more tricky questions for people managers to grapple with. So what we thought we'd do, as Tom was saying, is change the format of this webinar so that we're answering the questions that our clients are asking us and the questions that you as delegates have sent us before the webinar. So instead of doing the usual webinar function, we are going to go through a Q&A style for most of the session. So the main questions we're going to ask here, as you can see from the slide, is can I force my employees to get the COVID vaccine, and other really important questions. So if we have a look at the next slide now, this will give you a brief overview in terms of what we are going to look at this morning. So the Q&A session is the first up, and then we are going to move on at the end of the session to look at home working and the implementation of long-term home working plans, because lots of our clients, like us here at Freeth, have moved much more to home working in response to the lockdowns and the pandemic generally. And lots of our clients are telling us that this is not going to be a short-term situation, and they are therefore looking at ways of facilitating home working in the long term. So we're going to look a little bit at the risks and some of the opportunities associated with moving towards home working, including looking at equipment and financial considerations, how to keep in touch with your employees who are working from home, and some really helpful practical tips for you to take away from this webinar. And finally, as Tom said, there'll be another Q&A session where we answer your queries and questions that come through as part of the webinar. So if we're saying things, we're answering questions, and they're just creating more questions for you, please do feel free to use the Q&A function in Zoom, and we will do our very best to get to your questions at the end of the session. So now I am going to hand over to Tom, and he is going to compare the first part of our webinar today.
Brilliant. Thanks very much, Tom. So thanks all for the questions that we've received beforehand. So like Tom says, we'll go through those first, and then we'll move on to some of the slides later on, and then some of your questions that you've asked beforehand. So first of all, Toby, can I force my employees to take a COVID-19 test before coming back to the office?
Marvellous stuff, thank you, Tom. So I'm going to take this question as if it's someone who has not got symptoms. Can I make them take a test, or can I have a testing programme for symptomless individuals in my workplace? So NHS testing is only available for those who display symptoms of COVID-19 or have been advised to take a test by a medical practitioner or a public service. If you ain't got symptoms, you ain't getting a test on the NHS. Employers must not advise staff who do not have symptoms to get a test from the limited supply offered by the NHS. Don't lie to the NHS or Chris Whitty will get you. But they can offer, employers can offer alternative private provision, although there's no obligation for them to do so. So if an employer does want to introduce random testing or testing of asymptomatic employees, then they're going to have to fund this themselves. But what are the reasons for it? So it's understandable to think there may be some sort of health and safety consideration for testing employees, and an employer may regard it as a necessary invasion of that employee's privacy. For those who've been through the test, nose and throat swab, in essence, gagging yourself in a car park, it's really unpleasant. So an employee might feel it's an unnecessary invasion if they're not actually exhibiting symptoms at all, especially when there are other ways, such as social distancing, to ensure that a symptomless infection is not passed on to colleagues. So the employer is probably going to be in a stronger position if the workplace is one where it's quite difficult to maintain social distancing, but consideration is going to be needed to given as to whether testing is a proportionate way of addressing that risk, taking into account the employer's health and safety risk assessment, which of course you would have to evidence. For employers who do wish to introduce their own testing programme, the Department of Health has published some guidance to assist them in doing so. So the guidance advises that you've got to consider the scope of any testing programme, like who's it going to be for, who's going to be tested, the frequency of the testing, and arrangements for those who refuse to be tested, which I will come on to in a little bit, and how those test results are going to be used. They've also got to be aware of the data protection obligations in processing that data, how they're going to communicate to staff about how personal data will be used, and the compatibility of any testing program with their legal responsibilities. One of my other slides later on in the Q&A is going to be solely about data protection. I bet you can't wait for it, but you're going to have to because it's coming up a little bit later. Employers also need to think about how they intend to communicate to staff about a testing program. It is strongly advised, and I'm going to reiterate that, strongly advised that you consult with staff associations, unions, or the employees directly themselves, even electing employee representatives to discuss a testing program that's going on within work. Now, those aspects, that employee consultation is going to be key if you want to force employees to be able to take a test before they can return to work or whilst they're in work without symptoms at all. You can also consider alternatives to kind of the more invasive testing like lateral flow testing. The government has recently announced the extension of its lateral flow testing scheme for employers with 50 or more employees. That's unlike testing through NHS Test and Trace. Lateral flow scheme is specifically designed for employees without symptoms of COVID-19, but who could nevertheless still be infected with the disease. So employers who do meet the eligibility criterion can register for that scheme through the government website. The benefit of those tests is that you don't have to be sent off for a lab verification. Rather, once they get the test, employees will find out their results within 30 minutes. There's also a shift change here because the symptom full tests are designed for people who are evidencing those systems to confirm whether or not they have got the disease, whereas lateral flow is specifically designed for this particular scenario. So employees really should be considering that if they want to have that as the first part of any testing program. But to shorten those parts down, once you jump through those hoops, once you jump through the hoops of scoping, pricing out how much it's going to cost a business, consulting with the entirety of the workforce and seeking to reach an agreement about how this is going to operate, communicating all of this and considering our data protection obligations, then you can require an employee to take a test before they return to the workplace, or if they're in the workplace and they are symptomless. But you do need to jump through all those hoops first. You've also got to have this documented somewhere. Write everything down. It's worthwhile having these policies put in place so that you can communicate to anyone effectively. So we've got our testing program in place. What happens if an employee refuses? Can we force them to do it? So as long as we're entitled to process the data, and there's a health and safety need to administer those tests, and it's otherwise reasonable in the circumstances, only then can we consider how we're going to actually do it. Now, if we require an employee to take a test, now that could be what's considered to be a reasonable management instruction. It's us saying to you, we're your employer, we require you to take this step as part of your employment, and therefore it's an instruction that's based on health and safety. However, given the nature of that type of request and the fact that it's likely to be largely unrelated to an employee's actual duties, it's arguable that you're going to need something more to put an obligation on an employee to take a test or to make it kind of a quasi-contractual footing. So when we introduce a policy change, when we introduce a change to someone's contracts of employment, we need to talk to them about it. So if we're going to take those steps, we have to have gone through the necessary changes to the employee's employment contract, consulted with them about the change, and then sought to put that in place before we can go through this process of forcing them to take that test. If we then have that point where someone has refused to take it, we've got the contractual right or the policy right to enforce them taking it, and they don't, then at that point you could consider bringing disciplinary action against them. The fact is here, though, is that this is a really sensitive topic. We're saying to everyone, really, disciplinaries should be the very, very much the last resort here. So as part of that policy, you could introduce things like an internal tracing system, working out how you're going to work out which employees have contacted the other, and use this as part of the principle you build that testing program on. The need to tell other people within the workforce that they might be at potential risk. And a big, big issue for everyone here is going to be pay. If someone is refused access to work, but they're willing and able to do work, evidencing no symptoms, are they entitled to full pay? Well, yeah, unless there's something that says otherwise, like a contractual clause or a policy that's been consulted on. So the short answer to this, I always love these, the short answer to my ramblings on about the background explanation for this is yes, you can force your employees to take that test, but you've got a whole host of other considerations to go through before you get to that point. Tom, let me have my next question, please.
Yeah. So an employee is tested positive. Do I need them to have a negative test before I can allow them back into work?
Okay. So current government guideline says that they, if they have symptoms of COVID-19, then they need to self-isolate for 10 days from the onset of the symptoms or from a positive test result if they don't have any symptoms. Self-isolation ends when they're no longer presenting a risk of infection to others. So as long as the employee has complied with the government isolation guidance, then there's no legal requirement for them to test negative before returning to work. So the government guidance does not advise an employee to take another test or returning to work. So an employer should consider whether their instructions are aligned with that guidance, because they're not. So if you're saying to someone, you need to test negative before you return to work, you have to put in place a principle about why you're taking that step, because that's not something the government are saying that is necessary. If, as an employer, we're still insisting on having a test which shows a negative result first, then we need to follow the other considerations that I've just discussed in my previous slide as well. Now, I've actually had this, one of my clients had an employee, and they said to her that she needed a negative test to be able to return to work for some policy principles that they had there, and then the test took ages. So she was off work for a massive amount of time. Well, I say massive, much, much longer than we would have expected her to be, because we were waiting for that negative test. And if they just simply followed the guidance that was in place at the time and say, well, actually, issue presenting a risk to us, are we satisfied that the government guidance is being followed? Then she would have been back to work a lot sooner. So no.
Brilliant. Thank you. Then your favourite subject. How does workplace testing sit with data protection law, and what are the obligations?
So I mean, my thought process with this was that this is what our seminar should have been called. I know we went for the headline of vaccines and can we make people have them, but I thought people really don't want to know about that. People want to know about the data protection obligations they've got when having a testing or vaccination rollouts. So if an employer does want to introduce testing or vaccination records, they've got to know about the process that goes along with it in respect of data protection law. So the UK GDPR, as it's now known following Brexit, requires employers to show that they're accountable for the processing of personal data. If you're going to introduce a testing program in your workplace or hold any other type of medical information that relates to COVID, you will have had to have produced what's called a data privacy impact assessment. You must do this before you put a testing scheme in place, before you put that scheme in place. Right, the assessment itself is a big long document where you consider the nature, scope and purpose and context of the processing. You assess the necessity and proportionality and other compliance means you have around that testing process and what you're going to be doing with that personal data. You identify and you assess the risks to individuals, and then you identify any additional measures that you need to put in place to mitigate those risks. So when you're looking at putting a testing program in place, you're considering 4 aspects of data protection law. And you need to ask yourself these 4 questions. 1, do I love data protection? course you do, goes without saying, right? 2, do you really need that information? Will these steps, number 3, will these steps actually help you to provide a safe environment for your employees? And 4thly, could you achieve the same results without collecting any personal information? So in particular, without collecting any health information. As long as there's good reasons for doing so, data protection law does provide you with a lawful basis for processing health data in relation to COVID-19. So for public authorities, I think some of you on the call are public authorities, the public task processing basis is likely to be applicable. For other public or private employers, you're probably going to have a legitimate interest. That's probably going to be an appropriate use of that data, but you have to make your own assessment based on your organization and keep a legitimate interests record that show what those legitimate interests are and how you have assessed them. So you also need to consider whether the tests that you're running meet those requirements. If we're thinking of testing regime for health and safety obligations, are the specific tests that we're using satisfactory to meet that purpose? And we've got to remember that holding data for one purpose, health and safety reasons, is different to holding data for other purposes, like disciplinary purposes, like a refusal to have a test. So every piece of data needs to be covered, every use of that data needs to be covered in your documentation. But due to its sensitivity, health data is given a protected status by the UK GDPR. It's given the category of special category data. So as an employer, you need to identify an Article 9 condition for their processing. You can't just process it willy-nilly. So what's Article 9? Article 9 is a relevant exemption for use of personal health data. And there's probably going to be 2 here that most organizations can use. There's the employment condition and the public health condition. So do I need this health data so that employment can continue or to better facilitate that person's employment? Or the public health condition, which is, do I need that data for public health reasons? So either of these conditions will cover most of what an employer reasonably needs to do, as long as they're not collecting or sharing irrelevant or unnecessary data. Transparency on these ones is really, really important. As an employer, you need to be open and honest with employees and contractors from the start about how you need to process their personal data. That's crucial when processing health information. If you're testing employees or contractors for COVID-19 or checking for symptoms, you should be clear about what decisions you will make with that information or using that information. So where possible, you need to have clear and accessible privacy information in place for employees and contractors before any health data is processed whatsoever. And before carrying out any tests, you also need to know what personal data you require, what it will be used for, who you're going to share it with, and how long you intend to keep it for as well. You need to give that individual the opportunity to discuss the use of that data with you and whether or not they have any concerns. It's not simply enough to serve them a notice to say, we are going to be using your health data for this, as it is a protected category of data. This is all best done by using a data privacy notice for testing as well, which should be produced alongside your data privacy impact assessment. Thank you, Tom.
Thanks very much. Okay, the next question is, can I force some employers to take a test but not others?
So ultimately, there is going to be a balance here between legitimate interests in protecting the business and the health and safety and personal interests of employees. If an employee is showing symptoms, pretty straightforward, they should be taking a test. If they don't, then it might be a disciplinary action against them as well. If they're symptomless, it's obviously going to be a lot more tricky as well. But first protocol is going to need to be to rationalize the need for that test and then explain that to them. But we're always going to have in businesses the fact that employees are different. Each employee is unique in the way in which they perform their role. Some might work in significant close proximity to others, where social distancing or other measures are not possible. So a requirement for them to take a test might be deemed reasonable, whereas others in a socially distanced environment who aren't in contact with others or who have rolling patterns of contact within the office, it could be arguable that it's not in their health and safety, it's not in their personal interest to do it. So where we're requiring different groups to have different aspects of testing, we should always consider this as part of our testing program. Is it right to test everybody to keep it blanket across the board, or should we target it more towards people who might have different health and safety concerns with it? We need to understand the reasons why we're putting that in place. If it is health and safety, then it's probably not going to be likely to consider everyone across. If we do choose to opt to test some rather than others, we have to make sure that we don't do this on the basis of a discriminatory characteristic. You know, we don't just test people because of their race, because of their age, because of a disability. You know, we should be considering making sure that our testing program that we're using is fair and proportionate to achieving the aim that we're looking at achieving.
Brilliant. Thank you very much. Next question, I believe, is for Lee. Do I have to furlough an employee for childcare reasons due to homeschooling if they request it?
Thanks, Tom. So I disagree with Toby. I think this should have been the title of the webinar because we've just not heard enough about furlough over the last 11 months, have we? But in short, the answer to that question is no, you don't have to do this. As with any furlough leave, since it was introduced almost a year back now, there's no rules saying that an employer must furlough any particular employee. Ultimately, it's the employer's decision who it furloughs and when, as long as it's not using the scheme in a discriminatory manner. Though in reality, the vast majority of employers are mindful about the difficulties that the employees are facing, especially those who are forced to juggle work with childcare responsibilities, especially in light of the recent school closures. But of course, employers need to consider the operational requirements of the business. So for most employers, it's going to be a balancing act. If putting an employee on full-time furlough leave is not possible or desirable, but the employee is finding it difficult or even impossible to fulfill the terms of the contract, then hopefully there's going to be a workable solution somewhere in between. And this could involve, for example, agreeing a flexible furlough arrangement so that the employee only has to work a proportion of their hours. Remember, employers can still furlough employees for any amount of time or shift pattern under the coronavirus job retention scheme if the employee qualifies for support. Other potential solutions might include temporarily altering the employee's duties if it allows them to work from home, or maybe even temporarily reducing their hours so they can fit this around childcare responsibilities. This might be particularly an option. For example, if an employee has a partner who can help them with the childcare, they might be able to alter their hours so they're working later than they usually would. Although we must consider the effect on the employee's well-being if we are going to go down that route. But unfortunately, there is going to be the odd situation where an agreement can't be reached. If this is the case and the employee is not able to come to work or do the job, or stay at home and do the job even, then usually they're not going to be entitled to be paid. Of course, this is going to end up probably causing some resentment and some tension, so we would always recommend trying to find some middle ground if possible. Next question, please, Tom.
Gone too far there. Sorry about that. So
we need to go 3 back.
Great. Sorry about that. So can I force furlough on some staff but not on others when they do the same role?
So another furlough question. It's likely that furlough scheme is going to be extended in some form beyond April. And I know a lot of us have heard lots about furlough, and a lot of what I'm saying you will have heard before, but we are still getting questions about furlough. And if it is extended, we're probably going to be getting questions for some time. So that's why we've chose to cover it in today's webinar. So bear with me if you have heard all of this before. But so can you force furlough on some employees but not others who do the same job? The answer to this is yes, this is perfectly possible, but only if the employee firstly agrees to be furloughed. And as mentioned previously, the furlough policy is not discriminatory. So how do you get an employee to agree in these circumstances? And how do you ensure that this decision does not cause resentment from other employees who may not be furloughed? Well, our simple advice is to simply talk to employees about it first. Where there's multiple employees to choose from, it might be an option to ask for volunteers for furlough, or trying to agree a rota where employees take it on turns on furlough leave. If this doesn't resolve the situation, then you might need to undertake some form of selection process. One way of doing this might be to score employees against a range of selection criteria in a similar way as you would score employees for redundancy. So in these circumstances, an employer might choose criteria such as skills or current workloads. If you do opt to undertake a scoring process, again, it's important to make sure that the criteria can't be perceived as discriminatory. So an example would be selecting employees for furlough based on childcare responsibilities. While the employer might be doing this with its employees' best interests at heart, this could be perceived as indirectly discriminatory. For example, against women, if it can be shown that women would be more likely to be placed at a disadvantage because of childcare responsibilities. Once you've decided which employee or employees you want to furlough, you should then consult with them about the selection. As already mentioned, once selected, an employee will need to agree to be furloughed. Firstly, because the government says that they have to, and secondly, because putting an employee on furlough is likely going to constitute a change to the terms and conditions. If after consultation an employee still does not agree to be furloughed, then you'll need to consider alternatives. This might include other potential cost-cutting measures and ultimately whether a redundancy process is necessary. Hopefully things don't get to that stage and the employee will opt for the furlough option.
Brilliant, thanks, Lee. An employee is refusing to wear a mask. Can I make them?
So as we know, in some workplaces, it's a legal requirement for employees and others to wear a face mask unless they've got a medical exemption. As well as this, all employees have a duty of care towards their workforce, and this includes taking reasonable precautions to protect health and safety of employees and others using the premises, such as customers and clients. So even if wearing a face mask is not legally required, asking an employee to wear a mask at work could still be regarded as a reasonable management instruction if the employer's risk assessment concludes that wearing one is appropriate and necessary. However, if an employee refuses to wear a face mask, before waiving the disciplinary policy in the first step, what you should do is find out why they're refusing to wear one. And it may be that the employee has a perfectly legitimate reason for not wearing a mask. For example, they've got severe asthma, they've been granted a medical exemption. In this case, taking action against the employee is probably not going to be justifiable, but in keeping with its duty of health and safety, an employer should consider other steps that can be taken to mitigate any additional risk. And this might include, for example, putting a screen in place to separate the employee from others, or allowing them to wear a face shield instead of a mask. Another thing that you need to remember is if an employee has a disability, then in addition to general obligations around health and safety, employers also have a positive duty to make reasonable adjustments. So if a disabled employee is unable to wear a mask or their condition otherwise is likely to put the health at an additional risk, you should be considering what reasonable steps you can take to remove the additional risk. However, while in most cases employees who refuse to wear a mask are going to have a good reason, there's always going to be that minority what don't. For example, those who claim that wearing one's a bit uncomfortable, or those who are just being difficult. So in these circumstances, if the instruction is reasonable and you've considered all them steps, then it probably will be permissible to go down the disciplinary route.
Thanks, Lee. Next one is, can I dismiss an employee for failing to follow social distancing guidance outside work?
So when it comes to employees following social distancing guidance in the workplace, like wearing a mask, this could be grounds for disciplinary action. But what can an employer do if the breach is outside the workplace, outside working hours? Well, the employee is not going to be under the employer's control, and they've probably got an expectation to some extent of a private life. So if we do take disciplinary action in these circumstances, it might be a bit more risky. Whether we can do this is going to likely depend on two things. One, whether the employee's actions outside the workplace could have an effect on work inside the workplace, or two, whether the employee's actions have brought or could bring the employer into disrepute. Where an employee has breached social distancing rules, which have been put in place to protect the public, it's probably going to be clear that at least one of these 2 points will apply. Firstly, while employees have statutory duties towards employees and others, employees also have a duty to cooperate with their employer to enable the employer to comply with these duties. On this basis, an employer is often going to have a legitimate argument that by putting themselves at risk outside of the workplace, when the employee returns to work, they're putting others in the workplace at increased risk of catching COVID. As well as this, in some cases, the employee may not be able to come back to work if they become ill or have otherwise been told to self-isolate as a potential consequence of breaking the rules. And this could create significant problems, particularly if the employee's recently been in close contact with other employees in the workplace, and then they're also asked not to attend work. And then there are those employees who think it's a good idea to plaster photos of themselves breaching the rules all over social media for everyone to see. So if a member of the public then sees these photos, this will usually have a potential to damage the employer's reputation and bring them into disrepute. And this is likely to be a particularly sensitive issue for employees that work with vulnerable people, those in the medical care sector, for example, who've got additional safety standards to meet. and they need to be seen to be putting those standards in place. So these are all examples of potential grounds where an employer could justify taking disciplinary action against an employee who has broken social distancing rules outside the workplace. But even if disciplinary action, it may be permissible, like in any other case of misconduct, the disciplinary action still needs to be reasonable. And this will include ensuring that a reasonable investigation is carried out and there's a genuine belief that the employee has actually broken the rules. And this will involve looking at the evidence. The sanction imposed as well, if they are found guilty, should also be proportionate. This will involve giving consideration to particular facts, including the nature of the business, employee's role, any mitigating factors. Should also consider whether the rules are being implemented consistently. So if you've previously turned a blind eye to other employees breaching the rules, it might be hard to then justify taking really severe action against a different employee for breaking the same rules. And in some cases, there might be discrimination issues to consider here. So that's pretty much it from me for now. If, like Tom says, if you have got any questions, put them in the chat box below. We'll get to them at the end. But for now, I'm going to pass you to Tom Draper, who's going to answer some interesting questions on vaccines. On to you, Tom.
So, Tom, your first question, can I force my employees to have the vaccine?
Right, this is the big question that everyone's asking, isn't it? I heard a junior minister on Radio 4 the other day skillfully avoiding answering this question, and he specifically said, I will leave it to the lawyers. So I'm glad to be here to be able to answer it for you. It's a tricky question, which is obviously why a lot of people are talking about it. The starting point is that the government have decided to make the vaccine optional. So the government aren't requiring people to be vaccinated. It is a personal choice as to whether you're vaccinated or not. And therefore, obviously, the answer to the question is no. Employers can't force their employees to be vaccinated, in that they can't strap them down and make them have the vaccine. And so what employers mean when they ask this question is, can they implement disciplinary action? Can they potentially dismiss? Can they prevent their employees who are not prepared to be vaccinated from attending work? So it's a really tricky balancing act here between health and safety and personal freedom. So all employers are required to ensure that they have a safe working environment for their employees, but also their clients, their customers, their contractors, and in the health and social care sector, their service users as well. And the consequences of someone catching the virus from one of your employees could be very significant, especially, as I say, in the health and social care, elderly living type industries, where we have a number of clients who I've been assisting with this very question. And also there are commercial pressures on employers here. I've got clients who are telling me that the local authorities that they have contracts with to provide care for their service users are requiring them to tell the local authorities what they're doing to ensure that their employees have had the vaccine. And there have been widely publicised employers who've taken decisions in relation to this, like Pimlico Plumbers. And I also heard on the news that Saga are also requiring anyone going on their holidays to be vaccinated as well. So there is clearly a commercial pressure as well as a health and safety pressure on employers to encourage and potentially require employees to be vaccinated. But as I said, this is weighed against people's personal freedoms. It's a significant personal implication for an individual's freedom and liberty to have the vaccination and to make that compulsory, which is obviously why the government have stopped short of requiring people to be vaccinated. So when we're looking at any type of new situation, a new question like this one, it's a good idea to have a look at what the current situation says in relation to existing diseases. And there are some examples of employers in the healthcare sector, specifically in the NHS, where they require employees who in clinical settings to have vaccinations against TB and hepatitis, for example. But these roles are very few and far between. And arguably the coronavirus vaccine is different because there's less data about the effectiveness of the vaccine on preventing the spread of disease. And so obviously initial studies have been very encouraging in terms of the way that the vaccine is preventing the spread of disease, but there aren't as much in terms of data in relation to the coronavirus vaccine as opposed to established vaccines for things like hepatitis and TB. So when I've been advising clients, I've been encouraging them to look at this question as part of their overall approach to ensuring a COVID secure working environment. The clients that I've advised, I've suggested that they review their COVID risk assessments and look at what other precautions they're taking to prevent the spread of the virus. And in light of this and what we know about the vaccine, whether or not it's then reasonable to expect employees to be vaccinated. And in the vast majority of cases, the answer is going to be no. It's only going to be in very specific environments, such as health and social care, where you've got very close contact with vulnerable people, where it's even going to be a possibility to start requiring your employees to be vaccinated. So factors to take into account when you're making this decision include what the initial data is saying about the effect of the vaccine on the spread of the virus, how many of the vulnerable people that your employees are dealing with have also been vaccinated, because obviously if there's a high proportion of those people who've been vaccinated, then there's less of a requirement, or there's less of a push on us as employers to look at whether or not it's necessary to require our employees to be vaccinated as well. Ultimately, for the vast majority of employers, the answer to this question, as I've said, is going to be no. Even in relation to my clients operating in the care sector, we've stopped short of making it mandatory for our employees to have the vaccine. What we've done instead is we've set it out as an expectation, and we will then go on to look at each individual case of an employee refusing to have the vaccine on a case-by-case basis. My overall takeaway for anyone listening to this and considering this question in detail is that mandating vaccines has to be a last resort. There are loads of other ways of engaging with your employees, supporting and educating your employees, communicating with your employees about why it's important to have the vaccine, which hopefully will mean that it isn't necessary to make it mandatory. The government's produced a COVID vaccine update plan, and if you Google UK government COVID vaccine update plan, it'll appear for you on the web. And this has got some really useful information in it for employers and some really good ideas about how to tackle some common misconceptions about the vaccine and encourage employees to take up the vaccine when it's offered to them. So that's the situation in relation to current employees. The situation is slightly different and a little bit easier for employers in relation to new starters. So with new starters, it's easier to add this into a contract of employment because there isn't any risk that you're changing terms and conditions, because you're setting out the requirement from the start of their employment. But employers should still, however, be wary of the issues around this in terms of it being a reasonable requirement for the role, and whether it could be potentially indirectly discriminatory. So the Equality Act applies to job applicants as well as employees, and therefore there is potential that although this requirement would apply across the board equally to all job applicants, it could disadvantage particular job applicants with specific protected characteristic. And obviously the same considerations will need to be applied by employers who take the decision to make the vaccine mandatory for their existing employees as well. So some of those protected characteristics that might be affected are disability. So some employees or job applicants may have conditions that mean that they're prevented from taking the vaccine. Pregnancy and maternity is another area that is potentially protected here, in that employees who are pregnant may not be in a position to take the vaccine either. And then there's religion or belief. Now, the government have done a lot of work to counteract misconceptions about the vaccine containing various animal products that might make it difficult for employees from certain religions to have the vaccine. Those misconceptions have now largely been dispelled, but there are still some individuals who might cite their religion as a reason that prevents them from taking the vaccine. And then there's also veganism, and because the vaccine was tested on animals, there might be a belief in veganism that would prevent someone from having the vaccine as well, and therefore if there's a requirement for either job applicants or current employees to have the vaccine, then it may disproportionately impact people who are vegans. There's also the possibility, and this is just a theoretical possibility at the moment, but it's a possibility that the anti-vaxxer type belief against vaccines could be capable of being protected as a philosophical belief. My own view is that it's unlikely that as a belief is going to be protected by the tribunals, but still it's worthy of mention and consideration when considering why people are refusing to have the vaccine. Nevertheless, it's a sensible approach for employers before they take disciplinary action to listen to employees, listen to their concerns about why they don't want to take the vaccine, try and talk to them, try and support them, try and educate them, try and communicate with them and persuade them why it's a good idea to have the vaccine, rather than jumping straight into disciplinary action, because you can head off allegations of discrimination and you can head off the need to take that step, which would very much be a last resort.
Well, thanks, Tom. Next question is, can I ask for an employee to prove that they have or have not had the vaccine?
Yes, you can, but you need to think carefully about why you're doing this. Toby's already answered lots of this question in one of his answers in relation to GDPR and the requirements of employers to consider why they're asking for specific information from employees. So I'm not going to go into too much detail in terms of answering that question again, but I am just going to recap a little bit for you. There needs to be a lawful reason to process employees' data. And here we've got health data, which is special category data, and therefore there needs to be an additional consideration taken into account. And as Toby's already highlighted, in this particular situation, it would either be the employment condition or the public health condition. And so you need to think about which of those two would apply to your specific organisation before you start asking for employees to tell you whether they've had the vaccine or not. And then once you've asked the question, you need to think about how you're going to keep that data and to ensure that it's stored securely. And you need to ensure full transparency with your employees over why you're asking for this information and how the information is going to be processed. And I've been encouraging clients to revisit their privacy statements and their data protection policies to ensure that they are updated in line with this particular question and whether or not they're going to be asking that as part of that process.
Brilliant, thank you. Next one, can I remove entitlement to company sick pay if an employee refuses to have the vaccine and then gets the virus?
If an employee is contractually entitled to company sick pay, then removing this entitlement would constitute a variation to their contract. And in order to vary an employee's contract of employment, you'll need their consent. And if this is a variation to the contract that's just removing their entitlement to company sick pay, it's very unlikely that the employee is going to agree. With new employees, it might be possible to introduce this into their contracts in terms of allowing you as the employer to have the discretion to withhold company sick pay if the employee doesn't agree to be vaccinated. But for existing employees, it's unlikely that their contracts are going to contain this express provision. So you're going to be likely to be relying on a general discretion that's included in the employee's contracts of employment to withhold sick pay as their employer. So the first thing to do is look at the contracts. Do they give you this discretion? And if so, would it then be reasonable to use that discretion to withhold company sick pay from employees who are refusing to be vaccinated? You should also think about whether or not custom and practice has developed around the use of the discretion to withhold company sick pay as well. Because if it has, even if it isn't written in the contract, then it might be a breach of contract to apply the discretion in a way that it hasn't been applied in the past. So if an employer is seeking to exercise discretion to withhold company sick pay, this needs to be done on a case-by-case basis. So again, to avoid the types of discrimination allegations that I was mentioning previously, if you're going to withhold company sick pay and use your discretion to do that, then you need to understand why the employee is refusing to have the vaccine and whether they've got a protected characteristic that is potentially preventing them from doing that, because you don't want to inadvertently discriminate against someone.
Okay. Brilliant, thanks very much. Next one is, do we have to give paid time off to employees so that they can attend their vaccine appointment?
Okay, so currently there's no general right in law for employees to have time off for medical appointments. However, most employers are likely to want to support the national push for vaccination and allow their employees to attend vaccine appointments. And again, have a look at your employees' contracts of employment and your employment policies to see what rights your employees have for attending medical appointments. So where possible, it would be advisable to allow employees to attend their vaccination at the time slot that they are given. But if that isn't possible, especially with employees working from home, it might be a way, and you might be able to find a way around that so that the employee is able to attend at that specific time. But if you have a valid reason not to allow the employee to attend at their designated time, then it may be possible to ask them to reschedule their appointment for outside work hours, or for another time when it's possible to arrange their work schedule to accommodate the vaccination. Also, if the employee is offered a choice of appointment times, it would be fair to ask them to choose a time outside of working hours in order to minimize disruption on the business. If the vaccination appointment does take place during working hours, there's no legal requirement for employees to be paid for that time, but you may equally choose to do so if you want to incentivize other employees to get the vaccine. So it's part of this overall idea of encouraging people to take up the vaccine. In order to do that, then it's a good idea to think about whether it's possible to pay them to take the time off to do it.
Brilliant, thank you. And then the final one in this round of questions is, how do we manage employees who are refusing to come to work because a colleague has refused a vaccine?
Okay, so the starting point should be to communicate with the employee in order to understand the reasons why they don't want to return. So you should explain to them the measures that you've taken that are in place to ensure a safe working environment, and investigate whether other simple steps can be avoided to alleviate the employee's concerns. So I think the whole thrust of this seminar around testing and vaccination means that we would encourage you all as employers to look at the risk assessments that you've done and see how testing and vaccination fits into those, and decide whether your risk assessments need to be updated in line with that. And as part of that process, hopefully you're going to be in a position to reassure employees who are worried about returning to work that you've done absolutely everything possible to make the workplace COVID secure. Refusing to attend work would usually constitute a refusal to follow a reasonable management instruction. However, before taking disciplinary action, you need to be satisfied that firstly, the management instruction is reasonable, and secondly, that the employee's refusal to follow the management instruction is unreasonable. And again, obviously, communication is key. If the employee continues to refuse, but it's apparent that the employee is just being difficult or are otherwise behaving unreasonably, then disciplinary action could be permissible. It'd be a good idea to make a record of the communication that you've had with the employee, as this will go a long way to helping you as the employer convince a future tribunal that you've done enough investigation and that it was reasonable for you to take the disciplinary action if that is eventually required. All right, so that brings us to the end of our Q&A session. So I am going to pass on to Toby, who's going to take you through a few slides on home working during and beyond the pandemic.
Marvelous, thank you, Tom. That's great coverage of the vaccine stuff. I loved it. It's just also interesting. Yeah, so I'm just going to touch on really quite briefly on implementing long-term home working. There's normally like 4 reasons for this. So you've got an employee who doesn't want to return, an employee who cannot return, a business who doesn't want that employee to return, or where we're kind of ambivalent. We don't really mind whether they work from home or they do it in the office itself. I mean, we've been saying this, I've been banging this home working policy drum for the last year. You know, anyone who is home working needs a structure for how that work is going to be performed. You know, the home working policy itself should be a document that tells an employee the fundamentals that they need to know. You know, how they're going to be set up to work from home, who's going to pay for their equipment, how home working is going to be managed, expenses, tax, information security, our approaches to home working when we aren't going through a pandemic, other well-being considerations. Do we want the option to call that person into the business for specific reasons, you're gonna see, and I've already seen within the clients that I work with, a push for more people to remain home, a push for more people to be doing longer term home working, especially in the office-based environment, because they simply don't need to be in the office for this period of time. As long as we trust our employees, we've got structures around them. Employers, what we really need to be doing now is reviewing existing policies and practices. The best ones that I've been involved in is created this like home working contract pack. So you have people who then sign up to a new set of agreements, so that changes their permanent place of work to be their home, tells them that if you do call them into the office that won't be charged for travel time and you won't get an expense for that, and then gives them the statement of reasons why we would want them to come in, or an agreement with them when they will attend at the office on set days and at set times. Having those in place and having that structured out is just beneficial for everyone, but it also deals with people, how other policies are going to be managed for them, how disciplinary is going to be managed, how appraisals are going to work through. As I say, it's more likely that we're going to see people making flexible working requests, which is a requirement to consistently work from home. Everyone's got the statutory obligation, it's actually right, to be able to request flexible working once they hit 26-week service. But even if they're not at 26-week service, they can also make that request informally as well. Generally, an employer has a statutory obligation to consider that within 3 months of the request being received, if it's a formal request, and they can only turn it down for one of 8 specific statutory reasons, like reorganising work or burden of additional costs. Having those in place and how we are going to deal with those, and empowering managers about how they consider those requests is really important, because there is a general consideration of, well, look, if we allow one person to do this, allow one person to work from home, is it going to cause more people to want to do that? Discouraging other flexible working requests isn't a reason for turning down the one that's there. But the involvement that, especially within Freeth, that we've had with managing those types of issues for businesses, is that we're having more and more the businesses looking at, well, why do we need them in the office? Why do we need that person here? Is it so that we can manage them appropriately, which is quite appropriate for some people? Some people need that overall supervision. Can it be done effectively from home? Is there a need for that other access within people? Is it more beneficial to have a team environment? Other people talking about the same topics, that all feeds in, helps develop junior staff as well. All these things are entirely fine. All these things are reasons why we would want people in the office, but codifying that into a response and making sure that our responses to flexible working requests are, on the whole, and within a guiding principle, but also considered specifically for other remits like ongoing childcare needs, flexibility around supporting something like homeschooling if that's going to go on for a long period of time, or making sure that we don't act in a discriminatory fashion as well. But also we need to look at here about our ongoing requirement toward risk assessments. So we have a legal duty as employers to make sure that we have assessed a person's workplace for health and safety and for their welfare, as well as that applies with both their workplace in the office and also their workplace when they're working from home. Before implementing home working arrangements, and this was something back in last March when everyone got locked down, this is very tricky. So we should have been assessing whether or not someone can safely do their work from home, making sure their workplace is set up properly for them. It's now been almost a year where people have been working from home for extended periods of time. Risk assessments need to have been updated, but also we need to make sure that we're still consulting with employees about whether or not they feel they can do their work safely, whether or not they've got the right equipment there with them. Are managers keeping regular contact? Are we able to make reasonable adjustments for them as well? As lockdown starts to ease, and as we hopefully see the removal of a lot of these restrictions, things are going to return somewhat towards normal, hopefully. But in that scenario, the risk assessment requirement will kick in. They'll start kicking in a lot more detail, and we'll start having to undertake those more stringent risk assessments for people who are long-term working from home as well. You can do those at the moment with kind of a video call, but it might well be appropriate later on to have people fill out those forms or complete assessments in their home. We teach them and consult them about how to do that. Consultation is definitely key here. Talk to people about what they need, why they need home working, how we can support that, how we can support agile working as well. You're working at different times of the day. That's just really important. So I'm going to kick it over to Lee now as well to switch on a bit more about equipment and other financial considerations.
Thanks, Toby. That's all really helpful. So when it comes to equipment and expenses at present, usually an employer's obligations around this are actually quite limited, which can be surprising for some. For example, when it comes to IT and other work equipment, chairs, desks, stationery, there's no specific legal obligation on employers to provide this for employees to use at home. There's also no general legal duty on employers to cover household expenses incurred by employees as a result of home working, such as higher gas and electricity bills and broadband costs. However, there are some exceptions to this general rule. Probably the most obvious exception is going to be where the employee's contract entitles them to certain equipment or payments. In this case, if the employer will be in breach of contract if it doesn't provide these things. Another exception is where a blanket policy of not providing equipment or reimbursing expenses could be seen as discriminatory. And an example would be if a disabled employee is restricted so they have to work from home, and they're losing out as a result of the high costs of home working, this could give rise to a potential indirect discrimination claim. Another exception where a disabled employee may be concerned is where they need specialist equipment to perform the job effectively. So if a disabled employee requires, for example, an adapted chair, it might be considered a reasonable adjustment for the employer to provide it. Even though the employee is working from home and away from the employer's premises, the employer's duty to make reasonable adjustments for the disabled employee will still continue to apply. But even where there's no contractual obligation or discrimination risk, while it's not a legal requirement, it may still be in an employer's best interest to provide equipment for some employees. For example, if an employee is dealing with lots of confidential or sensitive information, it might be easier for the employer to comply with its data security obligations by providing its own devices. It might also be beneficial to provide financial assistance to employees whose own equipment or broadband connection, for example, is not up to scratch, to let them work from home efficiently. This is going to be a business decision for each employer to take. So if you do wish to provide office equipment and reimburse expenses, what are the tax rules around this? So in terms of equipment, if an employer provides employees with home office equipment, so desk, printers, monitors, and the rest of it, to enable the employee to work from home, then any private use of that equipment is insignificant. The provision of the equipment will generally be exempt from tax and NI. And before the pandemic, this exception would have only applied to items that an employer owns and has provided to the employee itself. It did not usually apply where an employer reimbursed an employee for the cost of equipment which they have obtained themselves. But for the current tax year at least, the government's applied an exemption to this general rule, so no tax liability will arise where employers reimburse employees who purchase home office equipment, as long as that equipment would have qualified for an exemption if the employer would have provided it. When it comes to reimbursing household expenses, the rules are a little bit more complicated. In some cases, employers will be able to reimburse household expenses tax-free, but only where the expenses are reasonable. They're incurred by the employee in carrying out their employment duties, and the employee is working under a formal home working arrangement. So what this means is expenses won't be exempt if they would have been the same regardless of whether the employee works at home. For example, rent, mortgage interest, council tax. The requirement for a formal home working arrangement also means that expenses incurred as a result of ad hoc home working, so not under some sort of pattern, will not attract the same favourable tax treatment. In terms of broadband costs, HMRC's guidance says that these will only qualify for an exemption where the employee did not already have them at home before home working, but needs broadband in order to work from home. So if you do wish to reimburse employees for expenses, you can currently pay each employee up to £6 a week or £26 a month without having to justify the amount paid to HMRC. However, if you wish to pay more than this £6 or £26 threshold, HMRC will expect you to ask the employee to provide evidence of the actual expenses, what they've incurred. And if an employer can't produce this evidence when requested, HMRC could take the view that actually those expenses wouldn't have been tax-free, and they may seek repayment of that tax and NI from the employer. So that's what I'm going to cover on equipment and expenses. I'm now going to pass you on to Tom, who's going to take us through the remainder of the home working slides.
Great, thanks Lee. So keeping in touch with your employees whilst they're working from home. Lots of employees are enjoying home working, but it does bring its own challenges as well. And it also brings its challenges for employers. So one of the employer's challenges is ensuring proper oversight of the work produced by employees working from home and dealing with any performance issues that arise. And here, as with a lot of things in HR, communication is going to be the key. So many employers have already put appropriate measures in place to keep in touch with their employees working from home, including setting up discussions groups on apps like WhatsApp and MS Teams and holding regular catch-up meetings. And we would suggest making these more formalized arrangements so that they don't fizzle out over time. I was speaking to another lawyer from a different law firm who said that she hadn't attended a team meeting since August. So it is possible for other employees to feel quite isolated when working from home as well. There is that consideration to take into account as well. And that's particularly potent when you're looking at addressing performance issues of employees who are working remotely. There's nothing to stop you performance managing employees working from home, but what I would suggest is listening carefully to the reasons why employees' performance appears to have dipped when they're working from home. There might well be other things that you aren't aware of that affect their home working environment that might have meant that the performance has reduced. And it might mean that you need to look at trying to do what you can to alleviate some of these difficulties before you start on a formal performance management process. And well-being is also important as well. So whilst obviously working from home allows a significant increase in flexibility and the reduced stress associated with the daily commute into work, it can also present its own unique challenges. Some employees find it very difficult to separate their work and home life, which can affect their mood and their work-life balance. And working from home for long periods can also increase a sense of isolation, as I mentioned. So employers should therefore bear this in mind when they're putting together their home working policies as well. Examples of ways to address this are include mandatory breaks away from work, discouraging employees from working out of hours, and holding regular meetings with employees to consult with them about their well-being, are all ways of trying to address some of the issues that can be thrown up in terms of the effect on well-being for employees working from home as well. So in terms of summarising this section of the talk then, the 5 practical tips and takeaways for you as employers. Implement a good home working policy. Keep your risk assessments up to date. When you've got employees working from home, as we've heard Toby and Lee mention, there are additional considerations in terms of health and safety and other things that would mean that you need to keep your risk assessments regularly updated. Consider whether equipment should be provided. Review existing policies. Is your performance management policy still applicable to home working as well? And also, as I mentioned just now, consult with your employees, communicate with them to ensure their continued well-being. So thank you very much for listening to our webinar. I can see that there have been loads of questions that have come up whilst we've been going through the talk. So I'm just going to look at the Q&A function now, just to see if whether we could pick up any of those in the remaining time. The first question is, I have an employee who returning from maternity leave and does not want to put their child into nursery and therefore wants to be furloughed. The work can be done from home, but not with the child at home too. Lee, do you want to take that one? You're on mute, Lee. someone was going to do it, weren't they?
Yeah, and it's always me as well.
Without someone being on mute.
Just so eager to answer the question. So as I mentioned earlier, there's no requirement to put any employee on furlough leave, and this includes employees returning from maternity leave as well. Ultimately, it's the employer's choice. Of course, just saying no is not always going to cut it, and it could cause some problems. So if an agreement can be reached, then try and agree it. But like I say, there's no obligation on you to agree it just because they come off furlough leave. It's there. If they don't want to put the child in nursery, that's a consideration for them. What you do need to remember, however, is that if you are operating a furlough policy, it's not discriminatory. So if you are putting other employees on furlough leave for other reasons, and you're refusing to put this employee on furlough leave because they've come back off maternity leave and they don't want to put the child in nursery, you might need to think, could that be perceived as discriminatory? Could that affect women more who aren't able to find, who have them childcare responsibilities? But as long as you're satisfied that the policy is not discriminatory and you've got good reasons for not wanting to use a furlough scheme in this circumstance, then ultimately you can ask them to come to work. So yeah, but try and find an agreement if you can. Hopefully there will be somewhere in between where you can maybe agree changed hours, different working pattern, that sort of thing.
Yeah, I think that's really sensible. I think it's akin to a flexible working request really here, isn't it? And so I'm not saying you need to formalise it in the way that you would with someone making a formal flexible working request, but the same considerations apply.
Yeah.
I think the current guidance on the furlough schemes is that you have to show evidence of a closure of a childcare facility or a school, or an employer can at least ask for that. So just not wanting to put your child in, I don't think that would even fall within the terms of the scheme.
There we go. So then we've had a few comments about rapid testing. What about rapid testing offered to a workplace with more than 50 employees? And then someone's commented, we have registered over a week ago, but not had a response as yet. I think you covered this bit off, Toby, didn't you, in your answer to one of the questions?
Yeah, they extended it. You can now apply. I imagine lead times on it are incredibly long. You might well satisfy the guidance, and yeah, they extended it, but actually getting the test kits is probably going to take a long time.
The next question, many of our employees are customer facing, so is that a strong enough business case to insist? I think this was in relation to having a test, Toby.
Yeah, definitely part of it. Certainly, yeah, definitely a consideration. Is there a public health obligation on us to make sure that people who are attending at our premises aren't going to be interacting with someone who had symptomless part of the disease? I don't think by itself anything is strong enough. I don't think we can be as reductive as to say that one thing is the final sort of breaker, but it's definitely part of that consideration, and it's definitely something for us to consider at that point.
Yeah, we'd have to look at it, wouldn't we, as part of the overall COVID risk assessment, wouldn't we? It's one piece of the jigsaw, certainly.
Yeah, there isn't a silver bullet on that type of thing.
Then a comment, government guidance is that once tested positive, you should not be retested for 90 days as likely to test positive again. Presumably this is the PCR test rather than the lateral flow test. Any comment on that, Toby?
Yeah, and I mean, that's it. I mean, that really supports my earlier argument to why bother? Why bother looking for a negative test? All you're going to do is potentially get a result that's either inaccurate and that person has to self-isolate for longer, or the delay is going to be there. My view is follow the government guidance. It's in place. It says it's in accordance with what the science says. It's in accordance with what public health says. As long as we are following that, then we've ticked all of those boxes. I personally don't think a negative test is necessary.
Okay, next question is for Lee. Can we furlough the employees who are off sick with COVID but on SSP only if we're genuinely still using the furlough scheme?
Yes, the guidance does let you do that, and I think in the past it's actively been encouraged by the government to use furlough where employees are off sick. You should, as you've sort of said in your question, you're genuinely still using the furlough scheme. That's an important point, that the guidance discourages using the furlough scheme if you wouldn't have otherwise considered using it, and you're just sort of doing it to make a bit of money. An example of this might be if an employee books a holiday, a usual holiday, and then you decide to put them on furlough leave just to cover the cost of some of the holiday. That wouldn't be encouraged, and you could face problems when it comes to claiming. But if you are actually using the furlough scheme, employees genuinely off sick, whether it's COVID or something else, then yeah, that's perfectly fine to do.
Okay, thanks, Lee. Okay, next question. We've implemented a form whereby staff are required to sign to say that they've read and understood the COVID risk assessment and that they agreed to abide by social distancing requirements. A small number of staff have refused to sign it despite being reminded. I think that this is clearly a reasonable management instruction, and ultimately, potentially, you could discipline employees who are refusing to sign this to say that they're going to abide by social distancing requirements. This is wholly different from testing and vaccines, which have implications for personal freedom and choice. This is about social distancing. This isn't just a requirement of employers. This is a requirement of the government as well. So I think that you would be in a strong position if you insisted that your employees sign to confirm that they're going to do this, and potentially disciplining them if they don't. Obviously, before you start any disciplinary process, communication with the employees, asking them why they're refusing to sign it is important, but presuming based on the likelihood that there isn't a reasonable excuse for not signing it, then potential disciplinary action is available to you.
Yeah, I think it's a strange one, isn't it? Because if they're just refusing to sign it because they don't agree with it, then they're still aware of their obligations, they're still aware of the government guidance, they're still aware of the importance of social distancing. So just because they've not signed it, that doesn't mean that we still can't enforce them rules. So regardless of whether there's a signature, they're still subject to them obligations and they still need social distance. So that it's not a way around it for them just to refuse to sign the piece of paper.
Yeah, quite right. Would the forcing employees to take the vaccine question possibly feed into scenarios similar to surgeons, for example, who are required to take certain jabs to allow them to operate? Yeah, this is the point that I mentioned in terms of looking at the situation currently in relation to existing vaccines such as TB and hepatitis. There are certain jobs in the NHS which are clinical jobs where there is a requirement to be vaccinated, and I don't think the NHS have gone quite this far in terms of making it mandatory for those kind of people to have the vaccine, just because of the fact the vaccine for coronavirus is new, and there aren't the same levels of data in respect of the implications it has for the spread of the virus. But certainly, if there are specific jobs that require close contact with vulnerable people, then it's certainly a possibility. But like I said when I was answering the question earlier, for the vast majority of the people listening to this webinar, it's going to be a step too far to require your employees to be vaccinated, and there could be significant legal risks associated with doing that. So looking at the next question, is it reasonable to ask employees to provide reasons for refusing the vaccine? I operate in the dentistry industry. Well, yes, I think it is certainly reasonable to talk to employees about why they're refusing the vaccine, and employees who are evasive or unprepared to enter into that kind of conversation aren't doing themselves any favours in terms of the way a future tribunal might look at the situation. As I said when I answered the question earlier, document everything that you do to communicate with employees, to find out why then they're unprepared to take a test or to be vaccinated. The better the paper trail that you have in terms of your attempts to communicate with employees about their concerns, the better it will be in future if there is any potential legal challenge. Okay, next question. Would you ultimately recommend that employers do have policies in place for encouraging vaccination? I don't think you need an official policy, but it might well be worth communicating to your employees what your position is as an employer over vaccination. As I say, care industry clients of mine have stopped short of making the vaccine mandatory for their employees, but they have communicated on a role-by-role basis, depending on the employee's contact with vulnerable people, whether there is an expectation that there will be those employees will take up the vaccine when it's offered to them. And yeah, I know a lot of employers are having this conversation internally, and I don't think it requires a specific policy, but it certainly does require communication of what the expectation is to your employees. If an employee has COVID symptoms and refuses to take a test, can we apply SSP only regardless of the CSP being contractual? Toby, do you want to take that one?
It depends on the contract. You know, if they've got COVID symptoms and they're required to stay from home, they're sick, very unlikely that the current contract, unless it's been amended, says anything about them being required to take a test. So I would say no, unless there's an ultimate discretion about whether or not you pay CSP, and you can say reasonably, well, because you've got the symptoms but haven't had those confirmed, we're not going to pay you for that period. No, I don't think so. I don't think that sits right. I think if there was a specific clause within it that said that you could, then okay. But my view would be that it would be fraught with danger to exercise discretion in that way.
Okay, the next one looks like it's for Lee. If working from home, do HMRC now allow travel to the office or work sites as starting from home, or do they still use from the office as the starting point for costs?
Okay, so I've not actually reviewed the HMRC guidance on this, and I've not been asked this before, but I would imagine the answer would be, I mean, at present, travel to and from work, as you know, you cannot claim tax relief on that. But once you're in the workplace, if you're carrying out travel for the purposes of your employment duties, then you might be able to claim tax relief on that travel. So if your home is your workplace rather than the office or the other place where you usually work, if you have an agreement to work from home, then I would imagine that travel from home to a client site, for example, would attract similar tax treatment as if you were traveling from the actual physical office. I don't know if you got anything to add on that, Toby or Tom, if you've come across this one before.
Yeah, I mean, that seems like the sensible and logical answer, doesn't it? This is one of the times where it's great to work for a national law firm that have a large tax law team, because you can legitimately say that if you wanted to email in, David, I can introduce you to one of our tax team, and they can give you a detailed answer to that question. Okay, if an employee does not want the vaccine, but they are made to in order to stay in employment by their employer, can they then sue their employer if they become vaccine injured and develop autoimmune disease, etc.? In theory, I suppose that might be possible, but I think the data that's available on the safety of the vaccine is very good, and I'm not aware of any direct safety implications of people taking the vaccine. I think there are a number of other hurdles that an employee in this situation would also have to get over. They would have to say that they weren't going to take the vaccine before they were required to do so by their employer, and then that the injury resulted from the vaccination as well. So I think in theory it would be possible, but in practice very difficult. While working from home and using Zoom or Teams, can you force employees to put on their camera? Lee, do you want?
Yeah, that one. I think it comes down to why are they refusing. If the broadband's rubbish and the computer crashes every time they turn the camera on, then it's probably reasonable for them to suggest not putting it on. And then that circumstance, you might want to consider whether you talk about them getting a better broadband connection. But again, it's likely going to come down to the reason, and also why they need to put the camera on. If it's a key part of their role to give face-to-face seminars, for example, to clients, and they're refusing to put on the camera, then that might be a bit more serious than if they're just refusing to put it on in a random team meeting on a Monday morning. So if you do consider it is a reasonable management instruction and the need to put the camera on to carry out the duties, and they're still refusing, then yeah. You might consider going down the disciplinary route, but yeah, first of all, find out why.
Yeah, I mean, like everything with HR and employment law, it's about two things. It's about reasonableness and about communication. So is it a reasonable management instruction to require an employee to have their camera on and communicate with the employee? What are the reasons why they don't want to have the camera on? Okay, next question. We've offered someone a position within our organisation. They are now requesting flexible working when working from home to support childcare. Do we have to support this request, or can we withdraw our offer? I'll take this one, and then you two can chip in if you want to. I think it would be risky to withdraw the offer in this situation because the employee has requested flexible working for childcare reasons, and therefore it might be discriminatory on the grounds of sex if you decide to withdraw the offer. What I would suggest doing instead is going through a normal flexible working procedure with the employee, talking to the employee about why they want flexible working, what the effect is going to be on the business. And if you do that, there are then 8 grounds on which an employer can reject a flexible working request. And as long as you genuinely have at least one of those 8 grounds in place, then it's relatively easy to reject a flexible working request. But I think it would be risky just to withdraw the offer.
Yeah, no, I agree on that. I mean, there's a conversation at the moment about whether or not they're going to extend the right for flexible working to be a day 1 right. But at the moment, that employee would have to have 26 weeks service before they can make a formal flexible working request. But you have to consider the informal one anyway. I think it's worthwhile in just considering that, deciding whether or not what they're asking for is appropriate, and then whether or not you can accommodate it. But I think if you can't accommodate once you've gone through that initial assessment, and then you are just simply saying, no, apologies, we can't support your request for these reasons, here's what the current terms we're offering to you are, that is then much better, I think, than withdrawing the offer. I think, as Tom said, I think withdrawing the offer creates a potential risk.
I think we are coming up against time, so I'll make this our last question. I appreciate there are questions that we haven't managed to get around to answering, so apologies for that. Tom, do you want to put our contact details up on the slide? You've got our email addresses there and phone numbers. Please do get in touch if you have a question that we haven't answered. Okay, so final question. The majority of our employees are in roles that need them to do international travel. When the travel restrictions start to lift, can we enforce a policy that employees traveling abroad must take the vaccine? again, that would have to be decided in line with the other approaches that you're taking to ensure a COVID secure working environment. I am aware of certain countries where you need to have inoculations against diseases that you might pick up in those countries, and so there is a precedent for doing this. But again, I think it would have to be decided on the basis of the overall approach that you as an employer are taking in respect of ensuring a COVID secure working environment. Anything else from you two? Lee, Toby? No.
Thank you everyone for coming.
Yeah.
Fantastic. Thank you everyone for tuning in. We've had a record number of people attending today. We had nearly 300 people signed up to this seminar. Please do look out for our next seminar, which is coming up in March. That's going to be on IR35, so we hope to see you then. Thank you, everybody.
Thank you.
Again.